Round number 2 of the Democrats' Nothingburger impeachment hearings are underway. It began with the Republicans yet again being given the shaft when it comes to calling witnesses.
Mr. Chairman, pursuant to Clause 2 of Rule 11, I move to require the attendance and testimony of Chairman Schiff before this committee and transmit this letter accordingly. Just a reminder, any no vote says you don't want Chairman Schiff coming, correct?
The clerk will call the roll.
Mr. Nadler.
Aye.
But when it comes to President Trump's objection to be pulled into Adam Schiff and Jerry Nadler's circus, the Democrats use that as a means to hold President Trump in obstruction of Congress.
This committee has voted to impeach 2 presidents for obstructing justice. We have voted to impeach 1 president for obstructing a congressional investigation. To the extent that President Trump's conduct fits these categories, there is precedent for recommending impeachment here.
The argument comparing Trump to Nixon is laughable, as President Trump wasn't part of a conspiracy to break into the DNC headquarters. Yet the mysterious death of Seth Rich, Hillary's breach of our national security, the technocracy in DNC's CrowdStrike debacle, and countless other Democratic abuses of power continue to go unanswered.
There's a difference between requesting investigations and a quid pro quo. You need to stick the landing on the quid pro quo. You need to get the evidence to support it. It might be out there, I don't know, but it's not in this record.
Nadler presented a panel of never-Trumper legal scholars led by Soros-linked legal counsel Norm Elson to use their imaginations to do as Schiff had done at the beginning of the impeachment inquiry, defraud the American people.
Imagine that the president had said, will you do us a favor, will you investigate Joe Biden? And the president of Ukraine said, you know what? No, I won't, because we've already looked into this and it's totally baseless. The president would still have committed an impeachable act, even if he had been refused right there on the phone.
If Washington were here today, if he were joined by Madison, Hamilton, and other framers, what do you believe they would say if presented with the evidence before us about President Trump's conduct?
I believe the framers would identify President Trump's conduct as exactly the kind of abuse of office, high crime and misdemeanor that they were worried about, and they would want the House of Representatives to take appropriate action and to impeach.
And they would find obstruction of justice, obstruction of Congress, and abuse of power, or some of them?
I believe that if the evidence supported those things in their minds, and if Congress determines that that is what the evidence means, then they would believe strongly that that's what Congress ought to do.
To in some way insinuate on a live mic with a lot of people listening that the founding fathers would have found President Trump guilty is just simply malpractice with these facts before us. That is just simply pandering to a camera. That is simply just not right. I mean, this is amazing. We can disagree. What's amazing on this committee is we don't even disagree on the facts. We cannot even find a fact right now where it is not going through the public testimony and also even the transcripts and all. It is not. Mr. Turley, are we going to deputize somebody between now and the founders into the jury pool here?
Well, first of all, only I will speak for James Madison. No, we all will speak for James Madison with about the same level of accuracy. I do find it rather surprising that you would have George Washington in this jury pool. I would strike him for cause. George Washington was the first guy to raise extreme executive privilege claims. He had a rather robust view of what a president could say. If you were going to make a case to George Washington that you could impeach over a conversation he had with another head of state, I expect his powdered hair would catch on fire.
Fortunately, George Washington law professor and constitutional expert Jonathan Turley was there to bring the cold reality to the Nadler crew's fantastical abuse of power.
So what I would caution the committee is that these crimes have meaning. It gives me no joy to disagree with my colleagues here. And I really don't have a dog in this fight. But you can't accuse a president of bribery. And then when some of us note that the Supreme Court has rejected your type of boundless interpretation, say, well, it's just impeachment. We really don't have to prove the elements. That's a favorite mantra, that is sort of close enough for jazz. Well, this isn't improvisational jazz. Close enough is not good enough. If you're going to accuse a president of bribery, you need to make it stick, because you're trying to remove a duly elected president of the United States. You can't say the president is above the law if you then say the crimes you accuse him of really don't have to be established.
The arrogance of the Democrats has yet again fallen flat on its face, while the business of the nation continues to sit in limbo. John Bound reporting.